Good evening, everybody. I am Manoj Kumar Chaudhary. Welcome you all on behalf of Nani Palkiwala National Law Club on this webinar. Today we have Jayprakash Somani sir, Advocate Supreme Court of India, Founder Director of Nani Palkiwala National Law Club, to give insight of Arbitration and Conciliation 1996 through 15 case laws in 20 minutes pleaded at Supreme Court of India. As we know, arbitration and conciliation is an alternative dispute settlement procedure which basically focuses on the settlement through mediation or conciliation, and that it's a different from the litigation which is basically happening in our court as a adverse manner. We all know that there are different case laws which are forwarded from the arbitration and conciliation to the Supreme Court to get it settled. So over to you, sir, to have an insight on arbitration and conciliations.
Thank you. Thank you, Advocate Manoj. Now see, friends, in 20 minutes, we will see first 15 case laws with the facts, decision, ratio, decidendi, and citation. And then I will give you the key features of Arbitration and Conciliation Act 1996. So today's our first case is Booz Allen and Hamilton Incorporation versus SBI Home Finance Limited 2011. Facts: dispute arose regarding the interpretation of an arbitration clause in a contract. Decision: the SC held that an arbitration agreement could be specific and need not be in an identical form in all documentation. So, SC held that an arbitration agreement could be specific and need not be in an identical form in all documentation. So, ratio decidendi in this, it's the intent of the parties to refer the disputes to the arbitration that is crucial. Then next second, Indian Oil Corporation Limited versus Amritsar Gas Service 2009. Facts: issue of jurisdiction in arbitration with respect to public sector undertaking. Decision: the SC affirmed that even in contracts involving public enterprises, parties can resort to arbitration unless explicitly prohibited. Ratio decidendi: the arbitration agreement must be adhered to unless there are compelling reasons to invalidate it. Citation: 2009 8 SCC 507. 3. National Agriculture Cooperative Marketing Federation of India Limited versus Alimenta SA 2007. Facts: dispute regarding the enforcement of arbitral award and the validity of the arbitration clause. Decision: the SC ruled in favor of enforcing the arbitration award. Ratio decidendi: the validity of arbitration clause should be upheld to respect contractual obligations. Very good decision. Citation: 2007 5 SCC 120. Chloro Control Limited, India Private Limited versus 7 Strands India Private Limited 2013. Facts: concerned about the validity of arbitration agreement between non-signatory parties. Decision: the SC recognized that non-signatories may be bound by the arbitration agreement under certain conditions only. Ratio decidendi: under the doctrine of group of companies, arbitration clauses can apply to parties not directly signatory. Citation: 2013 1 SCC 641. Case number 5, Messrs. K.K. Verma versus Union of India 1954. Facts: dispute regarding the applicability of certain rules in arbitration proceedings. Decision established that arbitration procedures must be followed as laid down in Arbitration Act. Ratio decidendi, arbitrators are bound by the principles of the natural justice. Citation AIR 1954 SC 321. 6. Basin Power Limited versus North American Coal Corporation India Private Limited 2016. Facts: dispute over the enforceability of an arbitration clause in an contract. Decision: affirm the importance of an arbitral tribunal in interpreting the terms of an agreement. Ratio decidendi, court should generally respect the arbitration process unless substantial legal issues arise. Citation 2016 10 SCC 813 813. 7. Haryana Urban Development Authority versus Amar Singh 2005. Facts concern the appointment of arbitrators and the provision of Arbitration Act. Decision clarified the process of appointing arbitrators under the Act. Ratio decidendi, the appointment of the arbitrator must be made with mutual consent. Citation 2005 to SCC 102. 8. Messrs. Indian Oil Corporation Limited versus Amritsar Gas Services 2009. Facts: parties disputed the contractual agreement and its arbitration clause. Decision: SC emphasized the significance of arbitration clauses in contractual for quick dispute resolution. Ratio decidendi, courts are duly bound to refer dispute to arbitration unless exceptions apply. Citation 2009 8 SCC 507. This is also very good decision, friends, which is in favor of the arbitration award, because alternative dispute resolution system is arbitration. So arbitration award should be upheld by the courts. But in article, when section 34 permits that of Arbitration and Conciliation Act, that time that arbitration award can be challenged in High Court or Supreme Court. High Court, and then after High Court in Supreme Court. Case number 9, Sri Ram Mill Limited versus Utility Engineers Limited. Uh, 1998. Facts: arbitration clause dispute and enforcement of an arbitral award were at stake. Decision: the SC maintained that courts should not interfere in the arbitration unless ground for interference exists. Ratio decidendi, judicial review is limited concerning arbitration award, which I already spoke with you. Citation 1998 3 SCC 652. Case number 10, Sukhvinder Singh versus State of Punjab 2007. Facts: jurisdictional issues regarding a dispute referred to arbitration. Decision: the court clarified that public sector disputes could also be referred to arbitration. Ratio decidendi, mutual consent and clear terms govern the arbitration process. Citation 2007 1 SCC 463. Case number 11, K.K. Verma versus Union of India 1954. Facts: dispute arose from a contract regarding arbitration proceedings. Decision: recognize the effectiveness of arbitration clauses in public contracts. Ratio decidendi, the scope of arbitration must be defined. The judiciary should not be undermined it. Citation AIR 1954 SC 321. 12. KK Verma versus Union of India 1954. This is a different case, and earlier was a different case. Cause title is same, but facts and decision are different. Facts pertain to a conflict in the appointment of an arbitrator. Decision: the SC recognized the need for clarity in the contracting parties' right concerning arbitration. Ratio decidendi: clarity and mutual agreement are a prerequisite for arbitration execution. Citation: AIR 1954 SC 321. 13. NAFED versus Messrs. E.I. Pont India Private Limited 2004. Facts: dissent regarding the arbitration procedure. Decision: enforce the arbitration agreement to ensure justice. Ratio decidendi: the arbitration process should prioritize the interest of justice and efficiency. Very good decision. Citation: AIR 2004 SC 5231. Case number 14. Venture Global Engineering versus Satyam Computer Services Limited 2008. Facts: issues regarding the arbitration process and jurisdiction arose. Decision: the SC reinforced the power of an arbitral tribunal to rule on its jurisdiction. Ratio decidendi: arbitral tribunal have the competence to determine their jurisdiction under the Arbitration Act. Citation: 2008 7 SCC 320. Case number 15. AAM International Limited versus UP State Agro Industries Corporation Limited 2022. Facts concerned with the enforcement of an arbitration clause. Decision: upheld the arbitral award and dismissed the appeal, highlighting the importance of finality of arbitration. Ratio decidendi: judicial and non-interference respect the autonomy of arbitrational process. Citation: 2022 9 SCC 580. Now friends, we will move towards the key features of Arbitration and Conciliation Act 1996. So you can find my one video on Arbitration and Conciliation Act, which is on in Hindi and English also. I think I have shooted that video 2 years or 3 years back, and that is available on my YouTube channel. You can watch that. So anybody, this series, specifically this series for lawyers and law students and law colleges. So this is only in English to English, but if any non-lawyer is attending this webinar, and if you want to understand what is exactly arbitration, how it works, so I recommend them to just watch that my video. You can understand basic of the arbitration. What happened now? Arbitration is very important in international transactions, specifically. National transaction also it is important, but national you have the if there is not arbitration clause in your agreement, then you have the open to go in regular court. Okay, but when you are doing any agreement with your foreign partner, foreign businessman, that time you cannot put case in your court because he don't have their jurisdiction and his country don't have your jurisdiction, like that. So at international level, when you are doing any contract of any agreement, not contract, legal agreement is called contract, and at international level we are always doing the agreements only. So MOU agreement, when our agreement or MOU contains the arbitration clause, that time it is very easy. We can appoint our lawyer. So A and B both are company, then A will appoint one arbitrator, B will appoint another arbitrator, and these two arbitrators appoint a third arbitrator, and that third arbitrator will be a chairperson of that arbitration bench, and they jointly take the hearings, and then within a 1 year, because this is fast resolution fast process of conflict resolution. So this happened. So it is very easy for international people to solve their disputes. Now I will focus on the key features of this Arbitration and Conciliation Act. One, alternative dispute resolution promotes arbitration as a means to settle dispute outside of the court. Scope of arbitration covers domestic and international arbitration. Arbitration agreement requires a written agreement to arbitrate in order to initiate proceedings. 4. Composition of arbitral award. Parties can choose their arbitrator and determine the number of arbitrators. It is not necessary that 3 arbitrators should be there. One arbitrator is also sufficient, but that should be your complete agreement. Then 6, arbitral award specifies the requirement for the form and content of award, emphasizing finality and enforceability. Interim measure provides provisions for interim measures by the arbitral tribunal or by courts. 8, recognition and enforcement. Arbitral awards are to be enforced as if they were decreed by the court, subject to the limited ground for the challenge. Judicial interference, 9 point. Judicial interference. Limit courts' intervention in arbitration process to specific ground outlined in the Act, promoting the autonomy of arbitral tribunals. 10. Conciliation provides a framework for conciliation as a method to settle dispute amicably. Before initiating arbitration process, always conciliation should be there. When mediation is there and both parties settle their issue in mediation, no need to initiate the arbitral process there. So conciliation, Act name is Arbitration and Conciliation Act, but conciliation is must first and then arbitration process. Number 11, fact track procedure allows for a fast track procedure to expedite arbitration in a certain situation. 12, time sensitive. Mandate the arbitral proceedings must be completed within a stipulated time, approximately in 1 year. 13, confidentiality. That means there should be a secrecy, confidentiality ensures that arbitration proceedings remain confidential. 14, appeal restrictions. Restrict appeal against the arbitral award to specific ground under section 34 only. 15, international arbitration rules recognize the validity of international commercial arbitration principles and offer needed supporting a domestic laws. These choose judicial precedent and structure features reflect the ongoing evolution and emphasize on arbitration as an effective dispute resolution mechanism in India. Friends, the Arbitration and Conciliation Act 1996 of India consists the following sections and chapters. I'm not giving all sections, just I am giving the numbers. 1, chapters. The Act is divided into 2 main parts. Part 1, main 3 parts, arbitration, part 2, enforcement of certain foreign arbitral award, and part 3, conciliation. And then major chapters. Chapter 1 is related to general provisions. It contains from section 1 to 4. Chapter 2, Arbitration, Section 5 to 43. Then Chapter 3, Conciliation, Section 61 to 81. And then Chapter 4, Miscellaneous, Section 82 to 86. For the So friends, these are the sections and these are the chapters. 4 chapters are there. Total sections are 86. But this Arbitration and Conciliation Act is very effective in corporate field, in business field, and for the growth of our country. Thank you. Thank you very much. Just give me a few seconds. I will unmute to Advocate Manoj to conclude this webinar. Advocate Manoj, you can unmute.
Thank you. Thank you very much, sir. Thank you all participants to have a part of and get an insight of arbitration and conciliations. We have discussed so many ratio decidency and key features like the party can select their arbitrator and then we can have a chairman of the proceedings. Then we have a we are using in a international arbitrations, but nowadays in domestic also it is getting more popular than that of a litigations. So we can have a more insight like this in upcoming webinars. Thank you very much to all. Thank you very much, sir.
Yes, and it is popular in domestic level also, क्योंकि तारीख पे तारीख ये जो कोर्ट का चलता है ना, ये अवॉइड करने के लिए arbitration through when somebody is trying to resolve their dispute through arbitration matter, so domestic arbitration is also good, but international level arbitration, though there is no other solution than arbitration proceedings at international level. Okay, thank you very much. Thank you, Manoj. Yeah.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।